Welcome to Justice for New York. I'm your host, Charles Collins. All documentation concerning Justice for New York videos can be found at justicefornewyork.com. There are also family court petitions concerning the right to a jury trial, petitions to vacate support magistrate and judicial hearing officers' orders as they are issued in violation of the New York State Constitution, and there is also a demand for probation reports and psychological evaluations that the court orders, but the court orders that you can't read them or see them. That is a violation of your right to due process and equal protection of the law. They also order that the people preparing these reports do not have to testify and there is no accountability. This has to stop. Demand your reports so you can know what's being told to the court. And now for our presentation. Thank you. Eric Schneiderman, as Attorney General of New York State, stated, as the top state's lawyer, he will stand up to powerful forces, defend underdogs, and go after bad actors on Wall Street and in government, regardless of party, politics, or power. Let's see how true that is going to be. All of our government officials are required to take an oath of office. The oath of office states, I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the State of New York, and I will faithfully discharge the duties of the office of, according to the best of my ability. Most of them are only giving lip service to their oath of office. The first thing we're going to discuss is the right to a public trial in family court. Now, if you walk into most of the family courts in the Capital District area, they have a waiting room where they guide you to. You are not allowed to go into the courtroom. They call you one at a time in, hear the case, you go out, then they call the next person in. That is not a public trial or a public hearing, which is required by law. The courts have consistently held, as they have stated, without exception, all courts have held that an accused at the very least is entitled to have his friends, relatives, and counsel present, no matter what offense has been charged. It is the law of the land that no man's life, liberty, or property may be forfeited as a punishment until there has been a charge fairly made and fairly tried in a public tribunal. The way that New York State gets around this is, and there is also a case that held that all our conclusion that all alleged civil contemners, like criminal contemners, have a right to a public trial. The threat of imprisonment is the coercion that makes a civil contempt proceeding effective. They close the courtrooms during these trials, during all the proceedings. One, it's in violation of state statute, but also the way they get around it is, and there was one case that held that no court has ever held that a person can be tried in a closed courtroom. Well, no court has. What they do is they don't address the issue. They find a reason not to address it, or they just ignore the argument. Therefore, they are stripping you of your constitutional right to an open courtroom. The courts have even held that in custody cases, you are entitled to a public hearing. If you read the uniform rules of the trial courts, it states, now this was done back in 1989, and that's going to be important in a minute. Family Court Uniform Rules, Section 205.4, Access to Family Court Proceedings. The court has held that the courtroom is open, that if the judge wants to close it, he has to do a written thing stating why he is closing the court. He can't just summarily close it. There are only 3 reasons given for closing the court. 1, the person is causing or likely to cause a disruption in the proceedings. The presence of the person is objected to by one of the parties. The orderly and sound administration of justice, including the nature of the proceeding and privacy of the parties, requires that all observers be excluded from the courtroom. But it goes on to state, whenever the judge exercises discretion to exclude any person, not just one person, any person, or the general public from a proceeding or part of a proceeding in family court, the judge shall make findings prior to ordering exclusion. I have never seen a judge in over 30 years issue an order stating why the courtroom is closed. They just closed it. As a matter of fact, as it will be documented, it took me 4 years to get a public trial. Now, in 1997, our illustrious Chief Judge Judith Kaye and the Chief Judge that followed her, Jonathan Lippman, decided that they were going to pull the wool over everybody's eyes by stating, they came out with their wonderful thing, stating they changed the 205.4 to, the family court is open to the public. This is 20 years later, or almost 20 years later, the family court is still closed. 1, it was open before they even came out with it. It has the same thing for closing the court, and also requires the court to issue any reason to close the courtroom. They can't just summarily do it. Even the judiciary article, sittings of the court to be public. The sittings of every court within this state shall be public, and every citizen may freely attend the same. That is very clear. Every court. Doesn't exclude family court. When they came out with this, there were some headlines. New York will open door on family court. It was already required to be open, and 20 years later, it's still not open. Family court wisdom. New York's Chief Judge moves to end a tradition of closed court proceedings. Not happening, especially in this area. Rules by Chief Administrator Jonathan Lippman. Didn't happen, stating that the court is now open. Now, as I stated, in 1997, Chief Judge Judith Kaye said the courts are now open. They're not. In 1998, I was helping the father of another child who happened to be my ex-wife's daughter. I went to the court proceedings. The attorney filed his list of who he was going to witnesses for the trial. There were 35 names on the list. Guess whose name wasn't on the list? Mine. I went to walk into the courtroom. He objected, stating that he was going to call me as a witness. I was never subpoenaed. Judge says you have to wait outside. I did that twice. Then I decided, no more. The court is open to the public. I filed a motion with the court, since the court says it's open to everybody, to the general public and everything. I filed a motion with the court to be allowed in the courtroom. It didn't get ruled on by the judge. It got ruled on by the family court clerk's office. And they sent me back this letter stating, inasmuch as you are not a party to the above matter and have no standing in this proceeding, the enclosed motion is being returned to you. The courtroom's supposed to be open. I'm aggrieved because I can't go into an open court proceeding under the law. What happened was, the following time going in, that time when we got to court, I got subpoenaed. The problem is they didn't pay me for showing up, which is required under the law. So I asked to speak to the judge before the court proceeding and explain that I'm entitled to be in there. The judge heard me, called the attorney in, and said, either you call him as your first witness or he's in the courtroom, and that I could stay after I was on the witness stand. So you have to stand up for what your rights are. The family court is required to be open. Schneiderman, Cuomo, why don't you, both of you, order the family court open and arrest these judges who are closing the courts illegally and in violation of the statute? It's very simple for you to do.